Hello again, it's John Crotts at King Law, attorney and elder law specialist. I'm going to talk to you today about mental capacity to sign legal documents like wills, powers of attorney, deeds. Um, what is required of our loved ones if they are uh, signing a legal document in terms of their mental or cognitive health and their ability to sign legal paperwork. Um, the standard varies depending on the type of document that they're going to sign, um, but essentially you've got very similar requirements for all. They need to understand what they're signing. They need to be in good cognitive health before we're going to let them sit down and sign legal paperwork. So let's start just talking about what a will would require as far as legal mental capacity is concerned. Um, a will actually has the lowest capacity required. The law provides that to sign a will, the individual has to understand the nature of the act, the extent of their property, uh, know who their heirs are, and know how the will is going to dispose of their assets. Um, in the law we call that the nature of what they own and to know what the natural objects of your bounty are, and that's basically just means who your heirs are, who stands to inherit from you if you were to die without a will, and who's going to inherit from you when you are based on the information that you're including in your will. um, and when we meet with people, uh, you know I always tell people I'm not a physician. It's hard for me sometimes to know exactly what all is going on in terms of that client's cognitive health. Um, but if we have reason to believe that they may not understand, then we will take a step back. We may need to meet with them privately without any other family present. That's actually the preferred way to make sure no one is, unduly influencing their decision. Make sure that what they're doing is entirely of their own choice and their own free will. Um, and if there are concerns that this individual may just simply not be in a good place in terms of their cognitive health, then we may actually get a physician's help and evaluate them to make sure that they're able to sign the legal document. Um, but but understanding what the nature of the act is, the extent of their property, who their heirs are, and how the will disposes of their assets are the basic requirements to sign a will. Um, a power of attorney, the requirements are a little different. It's basically contractual capacity. It's a little higher than the requirements for um, signing a will. So the individual must understand the authority being granted and the consequences. Um, so once again, we're going to put all those safeguards in place to make sure that they're really sure what they're doing and what the consequences of that legal document are. Um, you know, Occasionally we have situations where individuals may be hospitalized. They may be in a facility. Um, those are situations where we're going to go above and beyond, ensuring that individual fully understands what they're doing and that they don't have any medical conditions that might um, affect their ability to understand, that they're not on any medication that might affect their ability to understand. Um, you're certainly not going to rely on the assurances of family alone that individual is in a good place to sign legal documents. We're going to verify that um, based upon our own observations, our own questioning, and at times with input from physicians. Um, we and of course there are going to be occasions where we simply decline to allow that individual to sign because they're simply just not able to do so. Uh, the legal requirement to sign a deed is again the same as contracts. That individual must understand the legal effect of transferring the property. Um, Similar to drafting a trust, they have to understand the legal consequences of what they're signing. Um, and you know, there are times when an individual is signing a legal document that if we're concerned about outside influences or about uh, people challenging what we're doing, other family that may challenge that individual's ability We may even video record what's transpiring and ask a series of questions to make it clear um, in a video that this individual is fully aware and understanding of what they're doing, and there are no outside influences at the time they sign the document. Sometimes we do that as a practice, but usually not. Um, some different red flags that come up during the course of representing clients, particularly seniors uh, who may have some signs of early onset dementia or other cognitive decline. We may encounter fluctuating memory or confusion. Uh, you may have some actual diagnosis of a cognitive decline or a dementia. Um, when we're aware of that, we're going to take some extra precautions, likely going to consult with that physician or medical staff to ensure that this individual is still in a good place to be able to sign. Um, but you know, all these documents need to be witnessed, so there's typically going to be 2 or 3 witnesses involved. If you're talking about a will or a healthcare power of attorney, other types of documents only require a notary to be present, but we're usually going to have several of us involved in the room and make sure that whoever's signing that paperwork is in a good place to do that. Um, but you know, there's also triggers that are in place in trusts or even in a power of attorney, where in the event that that individual is unable to effectively manage their property or financial affairs due to their age or illness or mental disorder or medication they may be taking, that individual will no longer be able to act, and that can trigger a power of attorney agent stepping in or a successor trustee stepping in those types of situations. Um, so, but that's just a little information about the legal requirements to sign wills and other legal documents. We have to be careful, um, but if you have questions about this or anything else, let us know. We'd be glad to talk to you. Thanks.